So Manoj, Kochini was on the case because at that point of time, there was a contest and a preliminary objection raised as to whether this court under 32 could issue declaratory relief. And the contest was, were you required to file a suit under the Specific Relief Act? And the court said that no, we can issue declaratory reliefs. The only reason I'm mentioning this is, it's very important with regard to the nature of the declaratory reliefs, which your lordships have seen, granted in Minerva Mills. And here I'm just pointing out one para 75 has been placed repeatedly before your lordship.
So what is the principle from Kochini that you are extrapolating, Mr. Diwan?
No, the only, this is just prefatory. Declaratory relief can be granted by this court to declare. Here, thereafter, I point to paragraph 75 of Minerva Mills, and please see the nature of the declaration. The language is absolutely clear. And insofar as Section 4 of the 42nd Amendment is concerned, that is set out in Mr. Dwivedi's note in the Solicitor General's note, but you will find it at page 3966 of Volume 4.
We saw that. Yeah.
Your lordships have seen that. Now, Manoj, I want to just mention a dimension which is under judicial review. So I'll just state the points under judicial review. If the submission of the appellants or the petitioners here is accepted, then in our respectful submission, it will severely impact the power of judicial review of this court. And that ought not to be allowed. Now, let me indicate how. First, judicial review has been accepted right from Keshavananda Bharti as an entrenched provision, an entrenched feature, and therefore it's part of our basic structure. Keshavananda, your lordships will find there are observations in Minerva Mills, in L. Chandrakumar, all to that effect. I'll give you the paragraph numbers, but this is very, very well established. Now, how does this cripple and undermine judicial review is the point which I am seeking to press. The theory being put forth is that on a correct understanding, when your lordships issues a declaration, or issues or strikes down a particular provision seeking to amend the Constitution, there remains a hole in the Constitution. So it's some sort of a Swiss cheese full of holes that will result, and you will have a Constitution with hole after hole after hole. Now that cannot be and ought not to be a policy or a manner of interpretation that ought to be encouraged. An interpretation should be encouraged where the court is focusing on what is the provision, how is it infringing a part of the basic structure, how is it violating certain essential fundamental rights or other features of the Constitution. Not that the court should be focused on, oh, what will happen after I strike it down? Because there will be X hole or Y hole, and you will have a number of holes. So that's my first point. The second point I wish to make is that as far as judicial review is concerned under our constitutional scheme, it is not codependent on any other limb or branch of government. It's a power entirely vested in our constitutional courts. The theory being suggested by the other side is, and it develops and requires a codependence between not just the court, but also the court and the legislature to fill a gap. So I would respectfully submit that is contrary to separation of powers. It's contrary to the notion of judicial review, which is vested entirely and only in this particular institution. Do not please accept a set of submissions which will result in a situation where, despite your lordship's judgment and final declaration, there will still be something else required by somebody else for the purposes of a meaningful way forward. That's the second point. The third point I wish to make, which also touches on judicial review, is, so the third facet is really the efficacy of the judicial process. This severely undermines the efficacy of the judicial process if you are going to have a system or a suggestion or a theory which is accepted, which requires another branch to also give complete effect to what this court seeks to do in protecting rights of citizens. Now, please look at this examine this issue from another perspective, again from the judicial review angle. I would respectfully submit that please put your lordships in the, please put yourselves in the shoes of Parliament. In my respectful submission, had Parliament known that these particular provisions were indeed unconstitutional and stillborn, they would not have enacted the provision at all. It would never have been the intent under Article 368 to remove Article 39B and C. So they would, had they the knowledge or the understanding, when they brought about this particular constitutional change through Section 4, they thought, as your lordships correctly put it, they were expanding the scope. But had they known that this is something which will not pass constitutional muster, they wouldn't have done it at all. So therefore, the position we are canvassing, which is to say that the provision prior to Section 4, which has been now held to be unconstitutional and void, must obtain. Otherwise, of course, there are other submissions also with regard to the fact that there is a, that it will result in absurdity. But I am just placing this on another facet, which is judicial review. So that's my first set of points.
Oh, the first set of points, these four, right?
These are the points. Okay. Now I come to my second set of points. My second set of points is with reference to natural resource allocation case, the Constitution Bench judgment. Now, if you permit, I can take you to PDF page 558 and just place it, or I'll summarize it for you. I'll summarize the point for you. What this court has held essentially is that, look, as far as articles of, I mean, the Constitution is intended to endure, and so are these provisions, particularly the directive principles of state policy, because they are to guide the legislature and all branches of government moving forward for as long as the Constitution endures. Now, in a situation such as this, the Constitution Bench in natural resources, in the paragraphs which I have indicated, thought there was great wisdom in giving a wide interpretation to each of the expressions which was used within Article 39, and to leave it to the wisdom of governments, and in fact they use that expression as well, of the future, to interpret, to create, to define. So I am relying upon this Constitution Bench judgment essentially to advance the proposition that there may be great advantage in a situation where we do not confine the scope of these particular articles and sub-articles and leave it to the future for governments to recognize their contents depending on the exigencies of that age. So that's, my lords. Yes. So therefore, my lords, what the court emphasizes is that these are matters of policy which the government will eventually take a call on when the legislature steps in. So, my lord, that's my second set of submissions. The third, my lords, I'm going to request your lordships to just go to a few paragraphs of Mafatlal industry. So now I'm on my third set of points. So the context in which this discussion takes place is mentioned. So there was a judgment of Kanhaiya Lal, yes, which they eventually overruled for this relevant particular portion. And it's in that context. So if you permit, I can just show you those a few relevant paragraphs from that.
You can just tell us.
All right. So then, my lords, I'll give you the paragraphs. So please note the paragraphs of this particular of Mafatlal. So I am relying on para 76, particularly subclause 4, because there's a discussion on each subclause of para 76 separately.
In fact, 74 was also cited yesterday.
So 74 was cited. And then your lordships will just see that as far as the remainder paragraphs are concerned, the ones which, sorry, your lordship will just give me a moment. Yes, my lord, the discussion in Roman 4 begins at para 83 on page 2875, and the portions which the Solicitor General has also placed are paragraphs 84 right through till 86. So it was very much, my lords, an issue, and this is a 9-judge bench. We commend the same approach to the court. So, my lords, I am done as far as this set of points is concerned. Now, as far as MADA is, as far as the MADA Act is concerned, I want, with your permission, I want to just read one of the impugned judgments. So, your lordships have made it clear that that will probably go before an appropriate bench to discuss it. But I'd like to read, with your permission, 4 paragraphs from Justice Paintsay's judgment.
Into that.
All right, then I'll give your lordships those paragraphs. It will explain to you the perspective, my lords, because he's dealing with this particular act. And what is this common community of resources? What is the common good in the context of the Mahada Amendment Act? This discussion, my lords, in the context of the peculiar circumstances which was confronting the legislature and the ground situation is set out and explained by the division bench of the Bombay High Court.